Good morning everyone. Today I will be presenting the case of GENTING Malaysia BERHAD against PESURUHJAYA Data Perlindungan PERIBADI. So, this case is a significant decision by the High Court that addresses the governmental data demands and the personal data protection in Malaysia. So to begin the facts as follows, GMB or GENTING Malaysia BERHAD is a well-known resort word in Genting, Highland, Pahang. As part of its loyalty programs, it collects the personal data customer upon the registration. So what happened between them? So between November 2018 and November 2019, the IRB or Inland Revenue Board has requested from GMB to disclose the personal data of the customer, including names, IC numbers, and addresses. However, the IRB argued that this was necessary for the tax enforcement using the Section 81 of Income Tax Act 1967 and Section 39B subsection 2 of the PERIBADI 2010. So, what did GMB do? So GMB refused and citing the privacy concern and scared that the customer might sue them. So they filed a judicial review to the High Court. So the legal issue on two main question is whether the IRB request was valid under Section 81 of the ITA and whether complying with that request would breach the PDPA. So in its judgment, the High Court ruled in favor of GMB. It found that IRB request was unlawful and considered as a blanket demand. It found that Section 81 requires information to be tied to specific investigations, which is the illegal activity for the tax enforcement. So it is considered as a blanket demand for all customer data, and the court described this request as a fishing expedition. Additionally, the court ruled that disclosing the data without satisfying the condition under the PDPA, specifically under Section 39B subsection 2 of the PDPA, would breach the Act because IRB has failed to show that disclosure was necessary for the purpose of detecting crime or prevention the crime. So more importantly, the court emphasized that the right of privacy under Article 5, Subsection 1 of the Federal Court Constitution is closely tied to the personal data protection. The court also treated the letter by the Deputy Commissioner stating that disclosure would not breach the PDPA as a reviewable question. I agree with this, but it raises concerns. It could discourage the regulators from offering informal guidance out of fear of legal consequences, as noted by legal scholars like Aileen Kavanagh. Unclear boundaries between informal advice and legal decision could create uncertainty and overburden the courts. So in conclusion, this case sends a strong message. Government agency must comply with the safeguard of the PDPA and respect constitutional privacy rights. The ruling reinforces the personal data cannot be disclosed indiscriminately even to enforcement body without meeting a strict legal test, which is proportionate test and necessary test. And that's all from me. Thank you.